Thank you very much. And it's a pleasure to be with you, ladies and gentlemen, and maybe to try to discuss about, in fact, the enforcement of the GDPR. I've seen that normally the president of the Libe committee had to take part in some panels. I will have a meeting with the Libe committee after this speech, because we have, again, a structural dialogue with them. But I would like to thank the EDPS, Wojciech, and his team for providing us all with a platform to discuss how to ensure a strong enforcement of data protection rules. And often I have to address an audience, law enforcement and security authorities, industry, associations, who think that we have gone too far with EU data protection rules. I need then to argue and convince them of the need for strong data protection rules and a strong enforcement of these values and these rules. Listening to different points of views is enriching, and I'm open to consider improvement where needed. And we have tried to explain in a report after 2 years of the GDPR what is possible maybe to do, to go further, to go forward. I'm also happy to inform you that I very often manage to convince my interlocutors in those groups of people of the benefits of strong personal data protection rules for individuals first, but also for companies and society in general. And today, of course, the exchange is, I'm quite sure, different. We all share the same goal: how to ensure a strong protection of fundamental rights of EU citizens. The question for today is rather, what can we do more and what can we do better? Before embarking on this discussion, it is helpful to recall the reasons why the legislator designed the current GDPR enforcement model. The legislator had in mind 3 main considerations when developing the current system. First, preserve the principle of proximity. It was considered very important that individuals have the possibility to address their domestic data protection authority. It was felt that citizens would benefit from the possibility to exchange and interface with an authority that shares the same culture and the same language. This is certainly important for national and local cases, but also for cross-border cases. Cross-border cases all start with a complaint by a citizen or an organization in one member state. It is important that citizens can communicate easily with this authority at the beginning of the investigation, but also follow through this authority the various steps of the process. The second consideration after the proximity was to ensure the functioning of the single market by using the home country control principle. This principle guarantees uniform enforcement of rights across the Union to citizens. At the same time, it delivers the benefits of a one-stop shop to the companies. The same mechanism is used in other fields of EU law, and you have seen that we replicate sometimes the same rules in the different fields, and it was the case here with the one-stop shop mechanism. Of course, enforcement based on the home country control principle is a shared responsibility for all the authorities taking part to the system. This is so for the lead authority as well as for the other concerned authorities. Third, by creating the Open Data Protection Board, the legislator wanted to strengthen cooperation among national authorities. And it's very important that we have such a network of national authorities, and such cooperation is essential to ensure consistent interpretation and application of the law across the Union. And it's important for citizens, again, who should have the same level of protection across the Union. And the legislator aimed at developing a truly European data protection culture. This system also allows for the involvement of all concerned data protection authorities in the final decision-making process on cross-border matters. The EDPB and the cooperation and consistency mechanism inject an important European dimension in the system. This EU dimension is not an external element. It is not a top-down exercise. The European dimension is the result of the data protection authorities working together. It should be an integral part of their work from the investigation stage to the final decision. All legislations are tested on the ground. As Commission, we are looking closely at the concrete implementation, and we do not hesitate to intervene when needed. We are assessing the possible challenges in enforcing the legislation and how these challenges are or could be addressed. The effectiveness of the GDPR enforcement should be measured in terms of benefits delivered to the citizens, and benefits to the citizens derive often from the solution of many cases of national or local dimension that are dealt by the DPS on a daily basis. However, the number of cross-border cases, those that attract most public attention, is significantly increasing. Some of these cases include large companies and have an impact on many citizens across the Union. Of course, we should also acknowledge the big challenges related to the GDPR enforcement. And I want to say that we did indicate some of those in our report on the 2 years of application of the GDPR. Any possible discussion on improving enforcement should not be presented as a crisis of enforcement of the GDPR or as a reason to scratch completely the system. But the debate on the enforcement of the GDPR is helpful, and it is the responsibility of all actors to work together to deliver the best results to citizens. I listened, I will continue to listen with a lot of interest to the views and opinions of all the experts, starting from the data protection authorities and the European Data Protection Board. Their opinion is particularly relevant as they apply the GDPR using the one-stop shop and the cooperation and consistency mechanism daily. The Commission has consistently underlined the need for all data protection authorities to ramp up their efforts in enforcing the GDPR. A crucial aspect of this is the need for data protection authorities to cooperate efficiently and effectively using the tools provided in the GDPR, particularly in relation to cross-border matters. Effective cooperation between the data protection authorities is the key requirement for effective enforcement. Therefore, I welcome the series of guidelines the EDPB has developed concerning the functioning of the cooperation and consistency mechanism. The adopted guidelines on these issues streamline the application of the cooperation and consistency mechanism. This is the result of over 1 year of intensive common work between data protection authorities, and the outcome of the action against the EDPB decision in the WhatsApp case will bring greater clarity on the functioning of the cooperation and consistency mechanism. All those who are in favor of a strong enforcement of data protection rules should welcome and support the willingness of the EDPB members to strengthen cooperation on strategic cross-border cases. In Vienna, the EDPB members have also decided to work on a list of procedural issues which are leading to differences in data protection authorities' conduct of cross-border proceedings. The EDPB intends to consider how it may address those differences. I'm looking forward to receiving this list of procedural issues. I will feed into my team's reflection on how we could support the cooperation between data protection authorities on cross-border cases. I should also note that the enforcement of the GDPR sometimes touches on novel issues. There are cases where the regulation is being interpreted and applied for the first time to new technologies. It requires careful assessment and consideration. Clearly, in such cases, investigations and decisions by data protection authorities will take more time than more routine and more simple cases. The credibility of enforcement lies not only in adopting decisions, but also in adopting robust decisions that can stand the court's scrutiny. This applies to the substantive analysis as well as to the respect of due process requirements. Developing a truly common EU data protection culture between data protection authorities is an ongoing process, but it is certainly the direction we should follow, and we should make full use of the tools the GDPR provides, such as joint investigations. Now, of course, I'm hearing calls for more centralization. I understand this to mean putting more enforcement power in the hands of one authority at EU level. In fact, we already debated similar ideas when drafting the GDPR. But as I was saying at the beginning, the real question is, would centralization bring concrete benefits to the citizens? A different enforcement model has been retained, is true, more recently for the DMA and the DSA. Let me clarify, first of all, that these newly established enforcement mechanisms do not regulate the processing of personal data. They build on the GDPR. Data protection authorities remain responsible for questions concerning the processing of personal data and compliance with the GDPR. Second, based on Article 8 of the Charter, the enforcer of data protection rules be ensured by an independent authority. Therefore, the Commission could not have enforcing powers as it has in the DMA and DSA. And again, we need to take into account those different elements before to continue to discuss about a possible centralization. These legislations are also applicable to big tech companies and cross-border cases. However, the matters covered by DMA and DSA are different. When answering the question of what could benefit citizens most, we should consider that proximity and availability of a national authority is very important for citizens. Let me stress that the new legislations are also important as they may indirectly benefit the protection of personal data. For example, the DMA will stimulate competition and may increase the offer of products and services. This will enable citizens to choose services offering a higher level of privacy and data protection. As we all know, citizens are asking for that more and more. Privacy became an important parameter for competition. And in addition, under all these instruments, close cooperation between supervisory authorities will be necessary. Here, I would like to take the example of the ongoing dialogue between the Consumer Protection Cooperation Network, CPC. It is bringing together national consumer authorities and data protection authorities to discuss the intersection between data protection and consumer law. On the 2nd of May, together with Mrs. Jelinek, I had the pleasure of taking part in the fourth joint meeting between the authorities and observed their progress. And I want to repeat that it's very important to continue to try to put together all the national authorities to see how it's possible to go further in a better enforcement, with a better cooperation, and with a better common action. To conclude, I think that we should first make sure to use all the avenues already existing in the GDPR to strengthen cooperation among DPAs and enforcement of the GDPR. We should really strive to build this European culture for data protection. This should be a cooperative exercise and a shared responsibility. And in this, the EDPB may play a key role, as we explain in our 2020 report. One could also explore the possibility for more targeted initiatives enabling more harmonization and consistency in procedure. Using margins and potentialities for improvements to better the system should be our priority. This is in the interest of time and effectiveness. Opening a discussion to review the GDPR may also trigger other requests, completely different objectives, with completely different objectives. This may not be effective for citizens, as it may delay progress and have some unintended consequence. I will say that, I've said that during the presentation of our report in 2020, I'm sure that it will be a Pandora box to try to open a real discussion about the content of the GDPR, because I'm sure that you have quite all the same objectives in the way to reinforce the way to organize the correct implementation of the rules, but there are other trends in other directions, like I said at the beginning of my intervention. And so, again, I'm sure that we need to work more and more with the existing avenues that we have in the GDPR to continue to ask to the national authorities to work more and more together and to organize a better cooperation, but certainly also to build on the EDPB at the head of the network, the open network, to try to organize a common process and a common interpretation and a common implementation. But of course, I repeat that for some elements, it may be possible to think about different kind of harmonization. To do that, we need, of course, also a very strong legal analysis before to take any initiative. But I will be, again, very pleased to listen to your ideas, your views, and to continue such a debate, because enforcement is of the essence. It's not enough to pass a law or regulation like the GDPR. The most important element is to try to see, like you have asked today, how it's possible to enforce better. And I want to say that the GDPR, for the moment, is a child. After some years, we are already discussing about the way to better enforce. I'm sure that there are a lot of things to do, but not going too fast in different proposals to amend again such a regulation, with the risk to open many other debates in many other directions. But thanks again for such an opportunity to explain what we try to do at the Commission level to enforce better the GDPR. And thanks for your remarks and observations that we will, of course, take into account in the next steps. Thank you.